Dzień dobry panie i panowie, dobry dzień, good afternoon. Before I start, dear Edita, please reserve for me floor in overall discussion this afternoon. Thank you very much. My report is entitled Protection of Cultural Property in Ukraine During Russian Aggression. As needless to say that the Russian Federation is pursuing a deliberate policy aimed at crushing the cultural identity of Ukrainians. The strategy includes the destruction, damage and looting of Ukraine's cultural heritage. In an effort to distort historical memory, the leadership of the aggressor state has engaged all relevant institutions in the field of its history, culture and archaeology, subsequently appropriating the acquired artifacts to enrich the cultural heritage of Russia, this is a quotation, in the occupied territories of Ukraine. In 2015, shortly after the annexation of Crimea and the occupation of parts of Donetsk and Luhansk regions, a new Russian national security strategy was adopted by presidential decree. This document identified Ukraine and the Western influence as direct threats and outlined specific measures to counter these perceived dangers. By doing so, the occupying state is laying the ideological foundation for the aggression, a philosophy aimed at supporters of the regime, individuals preparing to fight, and those already engaged in hostilities on Ukrainian territory, ultimately seeking to justify its crimes in their eyes. In 2024, the Russian state strategy for cultural policy was updated to cover the period until 2030. This strategy now formally codifies the approach, explicitly stating, I quote, an important task in the integration of new subjects of the Russian Federation into the Russian cultural and humanitarian space. On the other hand, through indiscriminate and deliberate attacks on Ukrainian sites, the Russian Federation is actively destroying Ukrainian cultural property. The Russian armed aggression has placed an unprecedented number of cultural heritage sites and artifacts in Ukraine under threat. Since the start of the full-scale invasion in February 2022, numerous instances of the destruction of museums, historic buildings, churches, monuments, and other cultural objects have been documented. As Irina already told, according to UNESCO, as of April 2025, it's a recent information, damage to 485 cultural sites in Ukraine has been verified, including 149 religious buildings, 257 historical or artistic structures, 34 museums, 33 monuments, 18 libraries, 1 archive, and 2 archaeological sites. Between 2014 and 2025, the Russian Ministry of Culture issued approximately 1,500 open letters, permissions for conducting illegal archaeological excavations at cultural heritage sites in Ukraine at the occupied territories. These actions have resulted in the destruction of cultural layers and the appropriation of archaeological artifacts. These figures point to the scale of the humanitarian and cultural catastrophe accompanying the armed conflict between Russia and Ukraine. The destruction of a nation's cultural assets constitutes a loss for all of humanity, as a damage to the cultural property belonging to any people means damage to the cultural heritage of all mankind, as to UNESCO. The recognition of this threat necessitates the urgent modernization of existing international legal mechanisms for the protection of cultural heritage during armed conflicts, as well as the development of new, effective approaches to ensure the genuine preservation of cultural heritage in the states affected by war. The current war is viewed by many scholars and experts as a continuation of Russia's colonial policy, one inextricably linked with the destruction and appropriation of Ukrainian cultural heritage. The modern system of international legal protection for cultural property in times of war is based upon several key legal instruments. First, the primary document in this field is the 1954 Hague Convention on Protection of Cultural Property during the armed conflict, along with its 2 protocols adopted in 1954 and 1999. The convention obligates state parties to safeguard both their own cultural property and that of others during armed conflict. Furthermore, states are required to prohibit, prevent, and if necessary, put a stop to all forms of theft, pillage, misappropriation, or vandalism against cultural property. The convention also prohibits the requisition, forcible seizure, of movable cultural property from occupied territories. The first protocol of the Convention is primarily concerned with the prevention of the export and looting of cultural property from occupied territories. Adopted simultaneously with the Convention, the protocol provides detailed provisions concerning movable cultural heritage. Under its terms, each state party undertakes to prevent the export of cultural property from any territory it occupies during armed conflict. The second protocol to the Hague Convention was adopted in 1999, significantly strengthens the protection regime. It was introduced to refine the 1954 Convention in light of experiences from late 20th century conflicts, especially conflict in former Yugoslavia. According to it, state may nominate such properties like prominent sanctuaries or heritage landmarks for inclusion in the list of cultural property under enhanced protection, upon review by a Committee for the Protection of Cultural Property during Armed Conflict, a committee of the Second Protocol. So, during the ongoing war, Ukraine initiated the process of securing to enhance protection for a number of 27 sites, the biggest number of all states. And notably, already 2 of them had suffered from Russian missile attack. A key condition for this protection is that the parties to the conflict refrain from using the protected object for military purposes and from causing it any harm, even in cases of military necessity. The second protocol of 1999 also explicitly criminalizes serious violation related to cultural property. Article 15 of the protocol defines that such acts, including armed attacks against cultural heritage sites, unlawful appropriation or large-scale destruction of such sites, and acts of theft, looting, or vandalism constitute war crimes. Ukraine ratified this protocol only in 2020, having previously adhered to the Convention and the first protocol. The Russian Federation, in contrast, remains a non-party to the second protocol. In addition to the special legal instruments of the UNESCO framework, the protection of cultural property during armed conflict is also firmly anchored in the norms of international humanitarian law. The 1949 Geneva Conventions and Additional Protocol 1 of 1977 prohibit attacks on civilian objects, including those of cultural significance. Accordingly, the provision of Protocol and the Geneva Conventions are fully applicable to the international armed conflict in Ukraine, as both Ukraine and Russian Federation are the parties to the Conventions and the First Protocol. Thus, even outside the framework of the 1954 Hague Convention, Russian forces remain obligated not to target cultural heritage sites or use them for military operations. Within the context of modern international humanitarian law, the provisions are further supported by customary international law. According to the position set forth in studies conducted by the International Committee of Red Cross, the protection of cultural heritage is considered a peremptory norm, like jus cogens, imposing on all parties to an armed conflict the duty to refrain from any use of cultural property that may expose it to destruction or damage, to abstain from attacks against such property, and to take effective measures to prevent it looting, unlawful exportation, or vandalism. Since 2014, and particularly following the full-scale invasion of 2022, the Russian Federation has engaged in aggressive actions that have led to the systematic and planned destruction and damage of numerous cultural heritage sites in Ukraine. And these acts have been documented by Ukrainian authorities, international organizations, media, and constitute clear violations of aforementioned international legal norms. I will show a few examples of the most prominent cases by providing such examples by me. First, since 2021, Russian Federation has been carrying out illegal construction activities in the buffer zone of the UNESCO World Heritage Site called an ancient city of Taurik, Chersones and its Kora. These activities have led to the destruction of the archaeological and cultural layer over an area of approximately 900,000 square meters surrounding Chersones. Second, in the early days of the full-scale invasion, the Ivankiv Historical and Local History Museum near Kyiv was destroyed. On May 2022, a Russian artillery stroke completely destroyed the Grigory Skovoroda Museum in the village of Skovorodynivka, Kharkiv region, located on an 18th century estate where the famous Ukrainian philosopher and poet lived and was buried. The museum was hit directly by a shell, which caused a fire and consumed the entire structure of the museum. Another example, in June 2022, Russian shelling led to the complete destroy of the All Saints Hermitage of the Sviatohirsk Lavra, an architectural monument of national importance located near the city of Sviatohirsk. On July 2023, Russian missiles struck the buffer zone of the historic center of Lviv, UNESCO World Heritage Site. On July 2023, Odessa was subjected to the missile strike and damaged several buildings of the Fine Arts Museum, shattering windows in both the museum and the adjacent library. 2 days later, another missile attack caused fires and additional damage in central Odessa, notably the Transfiguration Cathedral, Odessa's main Orthodox church, originally constructed in 1794, was severely damaged. On September 2024, missile strikes were launched against the historic center of Lviv, again. It causes also death of 7 civilians. On October 2024, a missile hit the Держпром building located on Freedom Square in Kharkiv. On January 2025, Russian Federation launched another missile strike against the historic center of Odessa. Among the damaged structures were the Bristol Hotel with the civilians and also the building of Odessa National Philharmonic. I also want to stress that these buildings, Держпром and Odessa National Philharmonic, are the cultural monuments which are under enhanced protection. Especially according to the Article 15 of the Second Protocol to Hague Convention, it clearly constitutes a war crime punishable by International Criminal Court. Beyond the physical destruction of heritage sites, the Russian occupation has also been marked by a systematic looting of Ukrainian museums, cultural collections. The scale of this plunder is staggering. According to official data from the Ukrainian authorities, Russian occupying forces have removed approximately 1.7 million of cultural value from temporary occupied territories, 1.7 million items. This figure includes museum exhibits, archival materials, library holdings, and other objects that form part of Ukraine's cultural identity and cultural heritage. Notably, during the retreat from the right bank of the Kherson region in the autumn of 2022, Russian forces looted the majority of Kherson's museum institutions. It is estimated that around 15,000 items were taken only from the Kherson Regional Museum of Local Art and Kherson Art Museum. A similar scenario unfolded in Mariupol. After the city's capture in May 2022, the occupation administration organized the transfer of the most valuable artifacts from Mariupol Museum to Donetsk and, reportedly, then far to Russian Federation. The Mariupol City Council reported that more than 2,000 artifacts were stolen from the city museums. Among them were original paintings by renowned artists, including 3 works by Mariupol native Arkhip Kuinji and a painting by Ivana Ivazovsky, as well as a unique handwritten Torah and an 19th century gospel printed in Venice for the Greek community of Mariupol. Such actions clearly fall under the legal definitions of war crimes outlined in the first protocol of the convention and the 1999 second protocol of the convention, as well as the general prohibitions on pillage under international humanitarian law, and constitutes a war crimes according to the Article 8 of the Statute of International Criminal Court. It is important to note that the Ukrainian state has been actively documenting these cases. The Ministry of Culture and Strategical Communication of Ukraine maintains a registry of crimes against cultural heritage. As of 2025, hundreds and hundreds of incidents have been recorded and are being investigated by a Office of Prosecutor General. Based on the evidences, materials are being prepared for submission to International Criminal Court. The Ukrainian state also undertakes active measures to protect cultural property under wartime conditions. The basic in this is implementation of 1954 Hague Convention. And here comes a lot of problems. Ukraine actually is one of several countries which are trying to implement the norms which were adopted almost 80 years ago and previously had to protect cultural property during armed conflict. As an advisor to the Minister of Culture and Strategic Communication, I helped the minister to find a way to implement convention. Ukraine also is a member of Second Protocol Committee in UNESCO, Committee on Protection of Cultural Property during armed conflict. So as I told, we have already get 27 sites under enhanced protection. Also, according to decision of the committee, last December 2024, we asked the committee to launch a procedure of ad hoc monitoring. It's a special procedure which is connected to the monitoring of the sites under enhanced protection which suffered damage because of shelling. Actually, such commission is now working in Ukraine, and this is the first time in history such a commission was launched by the committee. But actually we are trying to implement other mechanisms, other institutions that are mentioned in the convention, in the protocol, and with no chance actually, because I call such a mechanism as international law archaism. Look, there is an institution like Commissioner General, which is stated in the convention. The Commissioner General is appointed by the UNESCO, and it's a special figure who can conduct a lot of activities connected with the protection, investigation, yes, preservation. It can be a negotiator with a party of the armed conflict. And because of and according to the convention, UNESCO must have a list of candidates that can be nominated to the Commissioner General. And when we asked a secretariat of the committee about the list, because we asked them, we want to launch a procedure of nomination. Even if Russia will not agree, we will try to implement, because it is necessary and it is an international norm. So we have been told that there is no list, and it never happened in 75 years that any state party to the convention nominated as a Commissioner General. Because of that, we do not keep such a list. It's a provision, but it's archaic. Okay. Another question is another mechanism. Every country, when it comes to a war conflict, to an armed conflict, must nominate a special representative on cultural property, both on its territory and on the occupied territory. So as Ukraine occupied Kursk, using its right for self-defense, prescribed by the Article 51 of UN Convention, we asked UNESCO and Second Protocol Committee, can you help us with the mandate of the special representative? Is it a body? Is it a person? What obligations? What duties the answer was the same. No one, state party, ever designated any special representative on cultural property, neither on its territory nor on occupied territory. Okay? There is another mechanism which was prescribed to help to preserve cultural property. Protecting power. If we are talking about protecting powers according to Geneva Conventions, yes, there were a few, one or two examples. But if we are talking about Hague Conventions, never. It never happened that existed any protecting power in any armed conflict since 1954 to help to protect cultural property. So that means that if Ukraine wants to implement the international mechanisms, it can be implemented because they are only on the paper. Yes, and UNESCO has nothing to do with it. It's a shame, but it calls for a conclusion I will state later. Based on the what I said and of all facts of I have mentioned, it's advisable to formulate a set of recommendations aimed at enhancing the effectiveness of mechanisms for safeguarding cultural property in Ukraine during armed conflict and in the post-war period. First of all, I think we have to intensify an international pressure and oversight. It is necessary to strengthen cooperation with the Second Protocol Committee of the UNESCO and other international bodies in order to enhance monitoring efforts and condemn violations committed by Russian Federation. Secondly, I think international criminal prosecution. That is one of the main points. Comprehensive evidentiary dossiers should be complied on individuals involved in crimes against cultural heritage, with a view to referring these cases in the International Criminal Court and competent local national authorities or national authorities of other states, as we know that war crimes under universal jurisdiction crimes, to ensure accountability for the perpetrator. Why I am mentioning International Criminal Court? Because International Criminal Court deals only with those war crimes who are planned, who are full-scale planned and committing as a policy. And we here clearly see it's a plan to destroy Ukrainian culture, it's a plan to destroy Ukrainian cultural heritage. And it's a policy of the state, of the armed conflict, to do it. So it clearly is Article 8 of the Statute of International Criminal Court. Restitution of stolen cultural property. An international campaign should be launched to demand the return of unlawfully exported cultural objects, with formal requests for restitution addressed to the Russian Federation in accordance with international legal norms. And parallel efforts should be undertaken to trace such objects through Interpol and other relevant mechanisms. Fourthly, implementation of reparation mechanism. Ukraine should initiate the legal formalization of claims for full compensation of damages inflicted upon its cultural heritage. This should include mechanisms for post-war reparations encompassing both financial compensation and the return or replacement of the lost cultural property. If you destroyed a unique property, we must have a right to ask you about property that you have in your museums, because we cannot evaluate even some properties. They are priceless. Fifthly, evacuation and digital preservation of cultural heritage. Efforts must continue to evacuate high-risk cultural assets and ensure to comprehensive digital archiving of collections, including three-dimensional scanning and cataloging. And sixthly, I think it's the main for the lawyers. I think we have to start the process of modifying or amending or updating existing international humanitarian law concerning protection of cultural property. We have to discuss. We have to conclude if some mechanisms are not working because they were launched 80 years ago in 20th century. We have to find a new solutions in 21st century, or to propose a discussion to look after these solutions. Because if we have international legal norms that are useless, then we cannot protect properly our property, that justice will suffer and then atrocities will continue. Thank you.